Okay. Are you Kevin Lee Tran?
Yes, yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictments and the motions?
He does, Judge.
Mr. Tran, in clause number 25, DCCR 0423, you're charged with the second-degree felony offense of assault on a peace officer from March 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
This was in there. And are you pleading guilty because you actually did what they charged you with? Sorry.
Yes.
And then in clause number 25, DCCR 0424, you're charged with the third-degree felony offense of assault on EMS personnel from March 14th of 2025. And how do you plead to that charge?
No contest.
Is it you're either guilty or not guilty? And are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? In those two cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Speak up, please.
Yes.
And Your Honor, I would ask the court to take judicial notice of the letter dated March 12, 2026. Should have thrown it in the first.
In what case?
All of these cases, Your Honor.
Okay, hold on.
Mr. Tran had been evaluated, was incompetent for.
Oh, hold on. Okay. Hold on. Thank you, Mr. Nicholas.
Yes, Your Honor, I should have done it at the onset, sorry.
Sorry, they're not in together. Okay, here we go. It's okay. I know. I just have to say it out loud. All right, I'm going to take judicial notice also in all of the court's files. And hold on a second. Mr. Tran was evaluated for competency and was found not competent to stand trial back in August of last year, was sent to the John Dunn Behavioral Science Center for competency restoration, received the report from them dated March 12th of 2026 that has the finding that Mr. Tran has attained competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
Not from the defense, Judge.
Not from the state, Your Honor.
Okay. Then at this time, based on that report, I will find that Mr. Tran is competent to stand trial. So now I got to go, where was I? All right, so I went through clause number 0423 and 0424. And so, Mr. Tran, did you go over the paperwork on the tablet with Mr. Lewis?
Yes, Your Honor.
And you fully understand it?
Yes.
And you understand, if I follow the agreements that you've made with the district attorney, that you're waiving your right to appeal?
Yes, Your Honor.
State tenders number 1 in each case.
No objection, Judge.
They're admitted in each case. Again, I'm going to find that Mr. Tran is competent to stand trial. Mr. Tran, I'm going to find that you entered your pleas of guilty in each of these cases freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 25 DCCR 0423 finds you guilty of assault on a peace officer, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0424 find sufficient evidence to find you guilty, and at this time find you guilty of assault on EMS personnel, sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-37560, I have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the state jail felony offense of theft of property, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, Your Honor.
And Judge, count one is one of the offenses we just pled to. Count two is one that's being dismissed. We could just do count one of these. That's all right with the court.
1 and 3.
Yes, Your Honor.
Just a second. And then in cause number 21-38780, I also have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the 3rd-degree felony offense of assault family violence by impeding breath or circulation. And that was a 5-year term in prison that was probated for 5 years. Is that also correct?
Yes, Your Honor.
Each allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of assault on an EMS personnel, the one that we just went through, from March 14th of 2025. And is that true or not true?
Yes, it's true.
And then count 3 in each case alleges that you committed the new offense of assault on a peace officer from March 14th of 2025, also the other case that we just went through. And is that true or not true?
Yes, Your Honor, it's true.
Did you enter your pleas of true in each of these cases to counts 1 and 3 freely and voluntarily?
Yes, yes,
And did you plead true to those counts because those counts are actually true?
yes,
In each of those cases, I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
yes.
And
Yes,
do you
ma'am.
fully understand them?
Yes, Your Honor.
And again, you understand if I follow these agreements that you'll be waiving or giving up any right to appeal.
Yes, Your Honor.
State tenders number 1 in each of these cases.
No objection.
It's admitted in each of those cases. All right, Mr. Tran, in each of these cases, in cause numbers 21-37560 and 21-38780, I'm going to find that you enter your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true. And 21-37560, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-38780, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in all 4 cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. I have just signed a dismissal in cause number 25 DCCR 0422 as part of that agreement as well. Good luck to you, sir. You can go back with the bailiff.
Yeah.
Miles? Okay, so this is 24 DCCR 2330, just trying to get up to speed. Good morning, ma'am. And Ms. Miles was in court and entered pleas of true to counts 1 through 4 in a motion to revoke unadjudicated probation. On probation for tampering or fabricating with physical evidence, a 3rd-degree felony, and I reset the case.
She pled true to counts 1 through 4, not
Right.
true to count 5.
Not true to count 5, which is the count with regard to that she was, so all of these have to do with, most of them have to do with the ISF and the fact that she didn't successfully complete it and was removed from it. And count 5 specifically made the allegation that she was walking around in the quote living room of the dormitory during count time, which was against the rules. We reset it and I asked for and received the a report, the discharge report from ISF. And so I guess where are we now?
So one of my main concerns is, and I'm not, well, obviously she's just started probation, but there is a history of mental health issues. I don't know if necessarily if Ms. Miles has been on the mental health caseload. There have been several diagnoses that she has. I'm not sure if proper medication may be an issue. I know she recently told me that they have put her back on some type of medication, which I do think has contributed to some of the behaviors. Due to her not being on probation very long and not being at ISF very long, we are asking that she be given another chance to try to make this right to successfully complete the probation. Mainly that was the issue on the motion, was her not completing ISF and adhering to all of the rules and regulations there. So I don't want the court to totally give up on her at this point, but we understand obviously that a person needs to successfully complete ISF when they are ordered.
I mean, what option? And just for the record, if you'll raise your right hand, please, ma'am, do you swear or affirm the testimony you're given this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so what options and what's probation's thought with regard to any type of mental health issues that could be addressed?
Well, prior to her placement at the facility, I did go to the county's corrections facility and speak with Miss Miles. And I told her that upon her completion of the ISF program, that I would have her meet with in Spindletop to have all of those assessments that she would need to see if that she could be accepted onto the mental health initiative caseload. But we didn't make it that far.
I guess the problem is if there are those issues, then those need to be addressed in order for her to be successful wherever, including ISF. So and those evaluations cannot be done while she's in custody at our jail, correct?
I don't know what can be done at the correctional facility, but I do know that I spoke to some members from Tacoma to have it set up to where they could start that process while she was at the facility, at the ISF facility. But due to her disruptive behavior there, it didn't get very far.
So if we need an evaluation done because the disruptive behavior could potentially be because of mental health issues, then what are my options?
I believe that the staff from Spindletop can go out to the facility and do some type of assessment.
I know we've had difficulty getting them to do that.
That's what my understanding.
Seen them there. I don't.
Yeah,
And I know Ms. Miles has been a Spindletop patient in the past.
you have go and behave
Judge,
if there's an underlying issue without
we
those.
said like we can request the records to see exactly what she was diagnosed and when the last time she was there.
Okay, let's do that.
I want to do that.
We'll do it whenever the next docket is. It's going to be a couple of weeks. We don't have a docket next week, but let's do that so that we can see what the diagnosis was so that we can figure out. I don't want to set Ms. Miles up to fail. I mean, and tell somebody to go and follow all the rules when there's behavioral potentially based on mental health. Now, if it's not, and there's just behavioral issues, then, that's gonna be on you. So it's not gonna be an excuse to misbehave and not follow the rules. But if there's truly an issue, I want to know about it and what those issues are, what the diagnosis is, and whether or not that diagnosis would potentially cause some of the issues that have happened. So
Yeah.
let's see. We'll get it reset and we'll come back, okay? Good morning.
Your Honor, before we get going, you'll recall the trial of the co-defendant in this case, where we got through certain testimony and with testimony, we decided to extend an offer to.
What was the name of the co-defendant?
Got it right here, Judge.
And have you,
Even with the name, you're asking a lot of me, Mr.
Yeah.
Pullman, but without a name, you're really asking a lot.
With Jose Lopez Palmias, it was a case where we employed the
Yes,
yeah, sorry.
that,
the translators from Houston and.
Yeah.
Yeah. Okay. And so something has been worked out based on that
Based on
in
that.
Mr. Rodriguez's case? Okay.
If Kenny Rogers theory of prosecution is what I was thinking, but that's the only thing.
Yes. Knowing when to.
The extent.
I thought it was Rivers, like, was Virgin Islands, was that what the Dolly Martin?
Mr. Turk, will your client waive the formal reading of the indictment?
Yes, no. I don't think it's true.
No, I'm talking about what in the whole.
I do damn right. We walk away from it.
Give me that. All right, Mr. Rodriguez, in cause number 23, DCCR 1415. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon from June 18th of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Defend myself.
Is anyone forcing you to plead guilty?
¿Alguien me está forzando a mí, declararse culpable? No.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with your attorney, with the interpreter?
Yes.
Do you fully understand
Sí,
them?
los entiende. Yes.
And do you understand if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
I understand.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I understand.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Rodriguez is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you, in accordance with that agreement, to a term of 2 years in prison. You will receive credit on that sentence for any time that you've been in custody, that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. And
We
You're-
submit a dismissal for the Shane case, Judge.
right, you're currently serving time in TDC, is that correct?
Yes.
This will run concurrently or at the same time with whatever you're serving time with as well.
La prisión.
And I will sign a
Thank you.
dismissal as part of this agreement and cause number 23 DCCR 1416. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. That admonishment is in Spanish. You need to read it carefully. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Turk. Right, good luck to you, sir. Thank you, Mr. Turk. Thank you, Ms. Bursch.
Thank you, Judge.